My Lord, I've put my name to this amendment too, because as you've heard, it's really important that parents should be able to discover what their children are being taught, and in particular, to see the materials. And it's arisen, as your lordships have heard, because the commercial providers of materials have apparently tried to stop parents getting access to those materials. And they've met those requests for information or to see the materials with the assertion that it's protected and they can rely on an exemption under the Freedom of Information Act. I find that surprising. The material has been, or will be, referred to in class to the children, perhaps slides shown. I should have thought that any duty of confidence on the part of the school to the commercial provider has been waived by that disclosure in class. But so be it. The effect of the assertion is to put parents off, and it puts the schools, as we've heard also, in an embarrassing and awkward position. The parents and the schools are on the same side. The issue is, of course, particularly sensitive where the subject matter is RSE, relationships and sex education, but it's not limited to that nowadays. History, economics, politics, a whole range of subjects raise awkward and difficult matters where there are strong differing philosophies and political views. And it's very important that parents should know what is being taught, in particular whether in fact their children are being indoctrinated, because things are not always the facts they appear to be. The content must be accurate and balanced. What this amendment will do will give statutory force to a policy to which we would argue there can be no reasonable objection. There is already, in the case of RSE material, statutory guidance provided by the government in 2019. And in parenthesis, I note here that only the other day, on the 17th of June, my noble friend the Minister wrote to Baroness Finlay, and I just quote one short passage, "When schools choose resources and external provision for relationships, sex and health education and PSHE, we expect schools to consult with parents on these matters and to make reasonable decisions about the content of their curriculum. Schools should also ensure that when they engage parents, they provide examples of the resources they plan to use, for example, the books that will be used in the lessons." Well, that seems to be the government's policy. Who could argue against that? And if that's the policy, what possible objection could there be to having it reinforced by statute which will meet the arguments put forward by certain providers? And in the statutory guidance itself, in 2019, the Secretary of State wrote this in the foreword: "We are clear that parents and carers are the prime educators for children on many of these matters." That's in the context of RSE. "Schools complement and reinforce this role and have told us that they see building on what pupils learn at home as an important part of delivering a good education." And under the heading Use of Materials, it continued at paragraph 13, "All schools must have in place a written policy for relationships, education and RSE," and it continued at paragraph 24, "Schools should also ensure that when they consult with parents, they provide examples of the resources that they plan to use, as this can be reassuring for parents and enables them to continue the conversation started in class and at home." Who could argue with that? It's common sense and uncontroversial. But parents, as we've heard, are not always getting access to which they're already entitled or should be getting. We've heard about the school where the school obviously felt on the spot because the provider didn't want them to see it. And what the provider wrote was that the material was exempt, and then it continued, "The placing of copies of the actual documents in the public domain by inspection or copying is not justified." What on earth does that mean? How can that be right? Not to put a copy in the public domain, not to show it to the parents. So there we are. This amendment, we would suggest, strikes a reasonable compromise. It doesn't require the schools to copy all the materials, and some of them may be quite lengthy, but simply to allow people to go into the school and see what is there. That will spare the schools the burden of copying. It's necessary, it's reasonable, but without it, it appears, parents will not be assured that they can, without recourse to litigation, see what their children are taught. I commend this amendment to the House.